The Judicial Branch. Article 3 of the Constitution created the judicial branch. It allowed for a dual court system between the Supreme Court and the other inferior courts that Congress creates. Section 2 of Article 3 grants the Supreme Court original jurisdiction in all cases affecting ambassadors, in those in which a state shall be party, meaning that the Supreme Court shall have appellate jurisdiction, meaning that the Supreme Court hears the appeal from a court that had original jurisdiction. The judicial branch is separated into 3 tiers: the district courts, the Court of Appeals, and the Supreme Court. The district court is the lowest court, formed of 94 district courts that deal with criminal, civil, and federal cases. 13 courts of appeals reviews cases from district cases. The highest court is the Supreme Court, which sets precedent and declares state or federal laws unconstitutional. Senatorial courtesy essentially means the president allows the senators from a candidate state to judge the suitability of that candidate for judgeship. The litmus test is simply an examination of the political ideology of a nominated judge. The Supreme Court considers the litmus test judicial philosophy, which is the way a judge interprets the law, and acceptability from the Senate when making judicial selections. Supreme Court procedures. Rule of 4, a practice that permits 4 of the 9 justices to grant a writ of certiorari which prevents a majority of the court from controlling the docket. Writ of certiorari is a legal document issued by the Supreme Court to request the court transcripts of a case, indicates that SCOTUS will review a lower court's decision. Stare is a rule or law contained in a judicial decision and is commonly viewed as binding on judges whenever the same question is presented. Precedent is prior cases whose principles are used by judges as the basis for their decisions in present cases. Amicus curiae brief is a person or group who is not a party to an action but has a strong interest in the matter and will petition the court to submit a brief with intent of influencing the court's decision. Oral arguments are the stage in the Supreme Court proceedings in which attorneys for both sides appear before the court to present their positions and answer questions posed by the justices. Opinions. Majority opinion is a court opinion reflecting the views of the majority of the justices or judges. Concurring opinion is an opinion that agrees with the majority in a Supreme Court ruling but differs on the reasoning. Dissenting opinion is an opinion in a legal case written by one or more judges expressing disagreement with a majority opinion. Judicial activism versus judicial restraint. Judicial activism is judges who go beyond their constitutionally prescribed duties of applying law to facts of cases in leg from bench. Judicial restraint is judges who avoid taking the initiative in policy, operating strictly with the Constitution, allowing the other branches to establish legislation.